How about liability that an agent broker may have from the mortgage company? So I'm purchasing the property, I'm now negotiating a short sale price with the bank for the $50,000 in our scenario. And the mortgage company later on finds out that I sold it to you for 75 with closing on the same day. Is there any liability for me with the mortgage company?
There can be, and let's identify one point a little further. And I think as you set up the scenario, you explained this transaction where the seller has the property listed. They may not have sufficient value to meet the amount of mortgage debt, and so they're looking to do a short sale. What I think ultimately creates a problem here is where the transaction is structured to avoid any possible responsibility or liability for the realtor. If the realtor who's serving as the investor or the short sale negotiator is taking some risk and treating it as an ordinary business transaction where they're an interested party and carry some of the burdens and responsibilities and the risk, there's less risk and less scenarios for liability. If I'm the realtor and I approach you, the seller, and I'm forthright and honest with you, identify that I'm self-interested, and rather than taking your listing, if I say, Chris, I see your property has $100,000 of debt, I'm interested in purchasing it for $50,000, I'll see if we can work down the bank and how much is owed so that I can purchase it for $50 and you'll be relieved of your underlying debt obligation. If that were to occur and I actually purchase it for $50, there's nothing that would prohibit me from going forward and reselling that property for $75,000 or even $100. If the market would bear that level of resale profit, then that's not illegal. Making a profit clearly is not a problem. What becomes a problem is anything that's misleading, deceptive, dishonest. And if I were to come to you and tell you that I will get you out from under any debt obligations and that does not occur, or if I go to the bank, and the question I think you're asking is if I go to the bank and represent that I'm the short sale negotiator working as a listing agent, and I fail to identify that I'm also the buyer and that I'm self-interested and that I'm going to resell this, and in some instances I'm even going to resell it before I close on it. Right. I just assign the rights in the purchase agreement. In any of those instances, it's more ripe with illegality and at least potential for more significant problems.
Yeah, that makes sense, and I can see where that would be. How about potential liability that you may gain, or I may gain in the scenario we've drawn up here? I don't find a buyer. So I've had the property on the market for 60 days or 90 days, and we're getting close to the end of that redemption period, and I say to the seller, sorry seller, I haven't been able to buy it. I'm not going to buy it from you. We're all done. Have a nice life.
Right. I think the seller could end up unhappy, believe it or not. I think there are certainly risks that are inherent in how you portrayed the scenario and to what parties. Sure. If I approach you as a listing agent and you're the seller and I promise you the world and ultimately don't perform, there's clear risk that I've violated licensing laws or my ethical responsibilities. If I set up the transaction by telling you, listen, I'm not going to represent you as a listing agent, I'm one of many potential purchasers, and here's what I will be willing to pay you to purchase the property, there's less likelihood of risk. As long as I'm forthright and honest, there's scenarios under which I can not have violated the law. I think where there's less transparency and where I'm misleading or where I tell you one thing's going to happen and it does not happen, I think that's where the risks enter in. And ultimately, I think the concern that a seller is going to have is if they're told by the real estate agent that they will be absolved from all liability from the mortgage company, the realtor or this investor may not be in a position to know that. Ultimately, that's going to be product of negotiation between the mortgage company and the seller. In some instances, the mortgage company may be amenable to letting the property sell for less than they're owed, and in other instances, they may not be. And if the seller's ultimately, at the end of the day, holding the bag and owing money that they did not know they were going to owe, or if the investor backs out, and the seller now has no ability to sell the property because they ran out of time, that's where the risks are going to occur.
Is there potential liability as well in a situation where I purchased it, or I gave a purchase agreement to the seller for the $50,000, I tried to resell it for $75,000, but we could have probably sold it for $60,000 outright without me being involved in it. Is there some liability there as well?
Absolutely. I think there has to be, because in that instance, what you ultimately did is limited the ability of the seller to market the property to a legitimate third-party buyer. if we know that there's a buyer out there who will purchase for 60, and I'm kind of in the middle of it, manipulating the transaction and in essence cutting the seller off from a legitimate sale, there's certainly potential liability there.
How about the Department of Commerce? Beyond what the mortgage company or especially the seller may have, what's the Department of Commerce rules as far as licensees and acting honest and not being deceptive? How does that all weave into the transaction?
Sure, that's an important point to note because the Department of Commerce is ultimately a regulatory body, and their interest and their sole role is to license the real estate agents and then ultimately to protect the consuming public from harm.
Right.
And so in the event that there's a real estate agent who's running afoul of the licensing laws, that's where the Department of Commerce is going to step in either on their own accord or by a complaint by a consumer or in some instances a fellow realtor and find out what kind of violations may have occurred. Ultimately, violations could be an agent who dealt with a party dishonestly, was fraudulent, deceptive, or dishonest. As I mentioned, that's all Chapter 82 prohibitions, which Department of Commerce then regulates and can find the agent responsible of violating.
Sure.
Another one is the duty that a licensee has to disclose any material facts to the prospective purchaser. So we often think of the material fact disclosure as a seller-only issue,
right,
where sellers have to disclose material facts about the property. Licensees have really a parallel disclosure, as you know, that requires them to disclose material facts to any prospective purchaser. And the fact that the negotiator that we're talking about may back out of the transaction and has self-interest clearly is a material fact. Another issue for the Department of Commerce's concern is the fact that the agent has to disclose their own self-interest. And if they're going to be a principal in the transaction, they have to identify that they're a principal or a prospective buyer, and they'd similarly have to identify that they're a licensed real estate agent. Right. So it ultimately becomes a question of how is the agent representing him or herself, and are they putting all the facts on the table?
And are they disclosing it on a regular basis? And as we both know, having it in writing is the key.
Absolutely, absolutely, yep.
How about E&O insurance? Somebody finds themselves in one of these situations and they say to themselves, I think I've made all those disclosures. I told them that, and we all know that when somebody hears something different, oftentimes it's not real admissible in court. How does E&O insurance work into coverage of a realtor or a broker in these scenarios?
Sure, that's a very good question because ultimately E&O insurance coverage may vary from one provider to the next. Our office happens to do a fair amount of E&O insurance defense work, and so we've had several instances where we can get a sense of what E&O insurance coverage does provide for and doesn't provide for. In many instances, a number of the policies out there provide no coverage if the agent is a principal in the transaction, buying it for him or herself or selling his or her own property. So in some of these examples that we've been discussing, if the agent is not only the negotiator or not only serving in the listing agent role, but also buying a property or selling the property, it may be an exclusion from E&O insurance coverage. And so in those instances, sometimes not only would any damages they're responsible for not be provided by E&O insurance, but in many instances their defense costs aren't even covered. So there can be a dramatic effect there, and it's something where an agent really should, if they're involved in these types of transactions, they should check with their E&O insurance provider as to whether this type of activity is covered. Check with their broker, because in many instances, if they're doing this without the broker's knowledge or permission, that creates a problem with coverage down the line and ultimately with broker supervision and management issues as well.
Good.
And the follow-up issue there on the E&O also is that anything that's done outside of the scope of real estate activity, however broad that's defined with the E&O provider, is not typically covered. So if it's something that the E&O coverage provider ultimately determines was not authorized activity or outside of the scope of their license, they may not have coverage there as well.
Terrific. Well, we thank you for joining us today. As I noted earlier, Brad has put together a very good article about this issue. If you have any questions, you could refer to that. Or if you're a broker or you're an agent as well, you could talk to your broker. You can call Legal Hotline to get more information or consult your private attorney. We thank you for joining Tuesday Talks today, and we hope that you'll tune in again. Thank you.